Imagine a situation where a person elected to serve the public trust must make a crucial decision that will affect many people. What happens when that decision also stands to personally benefit them, or their family, or their business ventures? This scenario highlights a core challenge in governance, a concept often examined in academic discussions of state political theory. A legislative conflict of interest is defined as a situation where a legislator's private interests, whether financial, professional, or personal, could improperly influence or appear to influence their official duties, decisions, or actions. It is crucial to understand that it refers to the potential for influence, not necessarily requiring proof of actual wrongdoing, to safeguard the integrity of the legislative process. The primary factors defining such a conflict revolve around the nature of the private interest and its direct connection to official legislative responsibilities. Key elements include direct financial gain, where a law or vote would specifically enrich the legislator or their immediate family. It also encompasses significant financial interests such as stock holdings, real estate, or business partnerships that would foreseeably increase or decrease in value due to legislative action. Furthermore, familial relationships play a critical role, as the financial or professional interests of spouses, children, or close relatives can be considered an extension of the legislator's own interests. Professional ties, like past or present employment, board memberships, or significant client relationships, also fall under this umbrella, especially if the legislation directly impacts those entities. The receipt of substantial gifts, favors, or the promise of future employment that could sway a legislator's judgment are additional considerations, all working together to ensure the public's trust in fair and unbiased governance. To address these concerns, many state legislatures implement disclosure requirements, obliging officials to publicly report their financial assets, sources of income, and significant business affiliations. This transparency allows for public and ethical oversight. When a potential conflict is identified, legislators often have procedures to follow, such as abstaining from votes, recusing themselves from committee discussions, or declaring their interests on the record before participating. These actions help to maintain the integrity of the legislative body and prevent the appearance of impropriety. Understanding these intricate definitions is not just about identifying individual wrongdoing. It is fundamental to the theoretical frameworks of democratic governance. For instance, the concept directly underpins the separation of powers doctrine by ensuring that legislative decisions are made on behalf of the public good, rather than private gain, thus upholding the principles of accountability and impartiality crucial to maintaining citizen trust in state institutions. These mechanisms are designed to protect the very foundation of fair representation. Ultimately, the rigorous definition and proactive management of legislative conflicts of interest are essential for fostering a robust and trustworthy state government. It ensures that laws are crafted and passed based on the collective welfare of constituents, rather than being swayed by the personal agendas or financial entanglements of those in power. This commitment to ethical conduct upholds the foundational promise of impartial public service.